Hi there, it's Friday the 25th of January 2019. I'm Steve Towers. Welcome to ITB. Let's get started. So let's start with a quick roundup of recent developments in regard to digital taxation. In France, the finance minister has provided some details about the country's proposed digital services tax. The legislation will be introduced into Parliament in late February. The tax will be effective the 1st of January 2019. The turnover thresholds will be 750 million euros globally and 25 million euros in France. And there will be a variable rate which will depend on turnover. The maximum rate will be 5%. In Spain, the proposed digital services tax has been included in the annual finance bill, which was introduced into Parliament last week. BEAC, the Business and Industry Advisory Committee to the OECD, has issued a paper with 11 recommendations for reform of the international tax rules concerning digital taxation. For a copy of the paper, please go to our website. And speaking of the OECD, don't forget the upcoming OECD Tax Talks webcast next Tuesday at 3 p.m. Paris time. I'm hopeful that Pascal will tell us about the emerging consensus within the inclusive framework in regard to digital taxation. To register for the webcast, please go to our website. I have one case for you this week. It's a decision by the Netherlands Supreme Court, and it's all about most favoured nation provisions. Let's start with the facts. A South African resident company owned 100% of the shares in a Netherlands resident company. In 2013, the Netherlands company paid a dividend to the South African parent. 5% dividend withholding tax was deducted from the dividend and remitted to the Dutch tax authorities. The 5% rate was in accordance with Article 10.2a of the South Africa-Netherlands Treaty. However, in 2014, the taxpayer requested a refund of the full amount of the withholding tax. The refund request was pursuant to Article 10.10, an MFN provision. Let me read it out. If under any convention for the avoidance of double taxation concluded after the date of conclusion of this convention between the Republic of South Africa and a third country, South Africa limits its taxation on dividends as contemplated in Article 10.2a to a rate lower, including exemption from taxation or taxation on a reduced taxable base, than the rate provided for in Article 10.2a, the same rate, the same exemption, or the same reduced taxable base as provided for in the convention with that third state shall automatically apply in both contracting states under this convention as from the date of the entry into force of the convention with that third state. Let me make a number of points in regard to this Article 10.10. Firstly, you will notice that the provision is triggered if South Africa concludes a relevant convention with a third country. The provision is not triggered if the Netherlands concludes such a convention with a third country. However, if the provision is triggered, the rate reduction applies to both South Africa and the Netherlands. Secondly, the provision is triggered if there is a relevant convention for the avoidance of double taxation concluded with a third country after the date of conclusion of the South Africa-Netherlands Treaty. This raises the question, what's a convention for the avoidance of double taxation? Is that phrase limited to a full-blown double tax treaty, or does it also cover a protocol to an existing double tax treaty? And thirdly, there's the issue of when is a convention concluded? Is it the date of signature or the date it enters into force? In regard to those last 2 points, the court accepted the views expressed by the lower level court. The phrase Convention for the Avoidance of Double Taxation covers both a full-blown double tax treaty and a protocol which amends an existing double tax treaty. And the date of conclusion of a convention is its date of entry into force. The South Africa-Netherlands double tax treaty entered into force and thus was concluded on the 28th of December 2008. That's a critical date because Article 1010 requires the convention between South Africa and the third country to be concluded after that date. South Africa had concluded a number of treaties which provide for a 0% dividend withholding tax rate. However, all of these treaties were concluded before 2008. For example, the South Africa-Kuwait Treaty, which provides for a 0% rate on dividends, entered into force and thus was concluded on the 25th of April 2006. And so the taxpayer pointed to the South Africa-Sweden Treaty. Now, the South Africa-Sweden Treaty is interesting. Firstly, this is one of those treaties, like the South Africa-Kuwait Treaty, which provide for a 0% rate on dividends, but which were concluded before 2008. The South Africa-Sweden Treaty was concluded on the 25th of December 1995. But secondly, this treaty was amended by a protocol which was concluded on the 18th of March 2012. And remember, a protocol is itself a convention for the avoidance of double taxation. This protocol did two interesting things. Firstly, it changed the tax rate on dividends to 5% or 15% depending on the level of shareholding. And secondly, it included its own MFN provision, the new Article 10.6. The increase in the dividend withholding tax rate to 5% or 15% is not going to help the taxpayer. But the MFN provision, Article 10.6, does. If any agreement or convention between South Africa and a third state provides that South Africa shall exempt from tax dividends arising in South Africa, or limit the tax charged in South Africa on such dividends to a rate lower than 5%, such exemption or lower rate shall automatically apply to dividends arising in South Africa and beneficially owned by a resident of Sweden, and dividends arising in Sweden and beneficially owned by a resident of South Africa. Now, there's one major difference between this MFN provision, Article 10.6 of the South Africa-Sweden Treaty, and Article 10.10 of the South Africa-Netherlands Treaty. Article 10.6 merely refers to any agreement or convention between South Africa and a third state. It doesn't expressly require that the agreement or convention be concluded after a particular date. And that allowed the taxpayer to put together this argument. In the South Africa-Netherlands Treaty, a 0% rate for dividends is available under the MFN provision, Article 10.10, only if that rate is available under a convention between South Africa and a third state, which is concluded after 2008. Although the South Africa-Kuwait Treaty does provide for a 0% rate on dividends, that treaty was concluded in 2006, and so that doesn't count, at least directly. However, under the South Africa-Sweden Treaty, the MFN provision, Article 10.6, allows a 0% rate if any agreement or convention between South Africa and a third state provides for such a rate, regardless of when that agreement or convention is concluded. Therefore, according to the taxpayer, the 0% rate under the South Africa-Kuwait Treaty triggers the MFN provision in the South Africa-Sweden Treaty, and so the 0% rate applies under the South Africa-Sweden Treaty. Critically, the MFN provision, Article 10.6, in the South Africa-Sweden Treaty is contained in the protocol which was concluded in 2012. That protocol therefore qualifies for the MFN provision, Article 10.10, in the South Africa-Netherlands Treaty. So, according to the argument, although the 0% rate under the South Africa-Kuwait Treaty cannot directly trigger the MFN provision in the South Africa-Netherlands Treaty, it can do so indirectly via the South Africa-Sweden Treaty. You could call this an MFN conduit situation. That argument was successful in the lower court, and it was also successful in the Supreme Court. A very interesting case. But before I leave this topic, let me point out something odd about Article 10.6 in the South Africa-Sweden Treaty. As you can see, it does not require that the agreement or convention between South Africa and a third state be concluded after a particular date. Thus, according to the court, it can be triggered by agreements or conventions which were concluded before, even years before, Article 10.6 was introduced into the South Africa-Sweden Treaty by the 2012 Protocol. But that's curious. At the time the 2012 Protocol was concluded, South Africa had concluded several treaties, including the South Africa-Kuwait Treaty, which provided for a 0% rate. That being the case, you do wonder why Article 10.6 was necessary. Why not just put the 0% rate into Article 10.2 of the treaty? A possible explanation is that the two countries wanted to allow the 0% rate to apply for only so long as a treaty between South Africa and a third country provides for a 0% rate. For example, if some years after the 2012 Protocol was concluded, the 0% rate no longer applies in South Africa's treaties with third countries, then arguably Article 10.6 turns off the 0% rate in the South Africa-Sweden Treaty. Maybe. In Australia, the government has launched a consultation in regard to the possible introduction of a reporting regime for sharing economy platform providers, such as Uber, Deliveroo, and Airbnb. The government has requested public comments by the 22nd of February. For a copy of the consultation paper, please go to our website. And now to India. Do you remember the decision in November by the Maharashtra Authority for Advanced Rulings that the back office services provided by an Indian company to a foreign company with no establishment in India are not zero-rated supplies for GST purposes, but instead are subject to 18% GST. That ruling concerned vServe Global. The critical part of the AAR's decision is that the Indian company was an intermediary as defined in the GST legislation. Well, now there's been another ruling issued in regard to a similar situation of back office services, and the same AAR has decided in the opposite way. The Indian company is not an intermediary and its services are zero-rated. For a copy of this second ruling, which concerns Asahi Kasei, please go to our website. In Belgium, the government is obviously trying to protect itself from any Danish or German-style cum-ex schemes. Legislation has been enacted which sets a prima facie holding period of at least 60 days for a pension fund to receive a dividend withholding tax refund or credit. The European Court of Justice has decided a case in regard to the taxation of insurance premiums. A UK insurance company entered into insurance contracts in regard to Finland. The insurance contracts related to the risks of buyers or sellers of shares in target companies due to a breach of the seller's warranties. Each policyholder was either a buyer or seller of such shares. Two particular scenarios were considered. In scenario A, the policyholder, who was either a buyer or seller, was established in Finland, but the target company was established in another member state. And scenario B is the opposite. The policyholder, again either a buyer or seller, was established in another member state, but the target company was established in Finland. Under Directive 138 of 2009, every insurance contract shall be subject exclusively to the indirect taxes and parafiscal charges on insurance premiums in the member state in which the risk is situated. And also under that directive, the member state in which the risk is situated relevantly means the policyholder's establishment to which the insurance contract relates. Based on those provisions, the court concluded that Finland has exclusive rights in scenario A, where the policyholder is established in Finland, but it has no rights in scenario B, where the policyholder is established in another member state. For a copy of this decision, please go to our website. And we have another case from the European Court of Justice. This case is called Morgan Stanley and it concerns VAT. The taxpayer is a UK company with a branch in France. The branch incurred expenditure which exclusively related to both taxable and tax-exempt transactions entered into by the UK head office. This is item 1 in the diagram. The branch also incurred general costs which related to both transactions entered into by the branch and transactions entered into by the UK head office. This is item 2 in the diagram. The issue in the case was how to calculate the amount of deductible input tax for the French branch in these two sets of circumstances. The court's decision sets out the calculation methodologies. For a copy of this decision, please go to our website. The Greens EFA group in the European Parliament has released a report on the effective tax rates paid by multinational companies in the EU. According to the report, many companies do not pay much tax in many EU countries, in absolute values or in comparison to nominal rates or to some other countries. For a copy of the report, please go to our website. In Germany, the Federal Ministry of Finance has issued guidance in regard to permitted deviations from the arm's length principle in the context of intra-EU transactions within a corporate group. The guidance is a reaction to the 31st of May 2018 decision of the European Court of Justice in the Hornbach-Baumarkt case. That decision indicated that the EU's freedom of establishment can, in certain situations, provide a limitation on the arm's length principle. According to the guidance, a deviation from the arm's length principle will be permitted if the taxpayer can establish that the deviation is required as a financial recovery measure for an affiliated entity or related corporate group. A financial recovery measure means a measure which is aimed at avoiding over-indebtedness or insolvency or ensuring the going concern status of the affiliated entity or related corporate group. Commentators have stated that the guidance represents a relatively narrow interpretation of the ECJ's decision. For a copy of the guidance, please go to our website. And now to Spain. I mentioned earlier that the proposed digital services tax has been included in the 2019 Finance Bill, which was introduced into Parliament last week. There are some other items of note in the Finance Bill. The proposed financial transaction tax. I covered this in ITB on the 2nd of November. Amendments to the participation exemption for dividends, capital gains, and foreign branch profits. These amendments reduce the level of exemption to 95%. The introduction of a corporate alternative minimum tax, and various amendments in regard to Spain's REIT regime. It's far from assured that the Finance Bill will be passed by Parliament without amendment. Spain has a small minority government. In Switzerland, as expected, the Swiss tax reform legislation, which is commonly called TRAF, is headed to a referendum, which will be conducted on the 19th of May. If it is passed by the referendum, it will likely be effective from the 1st of January 2020. And in the UK, the upper tribunal has decided a VAT case in favour of Tesco. This was an appeal by the tax authorities against the decision of the first-tier tribunal in 2017. The upper tribunal has dismissed the appeal. The case concerns a points-based customer loyalty program. The issue was whether fees paid by Tesco to so-called deal partners were consideration for supplies of services to Tesco. Both tribunals held that yes, they were. For a copy of this decision, please go to our website. In Algeria, the 2019 Finance Act has amended the income tax law effective the 1st of January 2019. Two items caught my eye. There's a cap on the deductibility of outbound fees for technical assistance. The cap is mainly set as a percentage of the turnover of the payer. And there's a new 5% withholding tax which applies to sales via internet platforms. And in South Africa, the tax authorities have issued guidance on the tax treatment of foreign dividends. For a copy of this guidance, please go to our website. In Qatar, a new income tax law has commenced operation, although there are only a small number of significant differences from the previous law. The standard corporate income tax rate remains at 10%. However, the 35% tax rate, which formerly applied to agreements relating to petroleum operations, will now also apply to agreements relating to the petrochemical industry. And the 7% withholding tax rate has been abolished, and there will be a 5% withholding tax rate on outbound royalties and service fees. In Saudi Arabia, the tax authorities have released the English language version of guidance on the VAT treatment of agency arrangements, and in particular, agency arrangements between hotel owners and third-party hotel operators. For a copy of this guidance, please go to our website. In Brazil, an ambitious plan to replace a range of existing indirect taxes with a single VAT has been proposed by the Special Committee on Tax Reform, which is a committee in the lower house of Congress. The plan will now be considered by the full lower house. In the US, New York State has finally issued some guidance in regard to the impact of the Supreme Court decision in the Wayfair case on the 21st of June 2018. You'll remember that I did a survey of US state reactions to the Wayfair decision in ITB on the 28th of September. The New York State guidance, which is called Notice N19-1, states that the Wayfair decision activated certain existing provisions in the New York State tax law that define a sales tax vendor. Those provisions immediately became effective. As a consequence, businesses that fall within this definition and make taxable sales in New York are required to collect and remit New York State and local sales tax. The key paragraph in the guidance is this: a business that had no physical presence in New York State but has both more than $300,000 in sales of tangible personal property delivered in the state and conducted more than 100 sales of tangible personal property delivered in the state in the immediately preceding 4 sales tax quarters is required to register as a sales tax vendor and collect and timely remit the applicable state and local sales tax. The sales tax quarters are March 1 through May 31, June 1 through August 31, September 1 through November 30, and December 1 through February 28, 29. As you can see, this two-pronged threshold is consistent with the general model adopted by most states in their post-Wayfair guidance or legislation, subject to one important qualification, and that's the references to tangible personal property. The New York law will not apply to out-of-state vendors which supply services over the internet which do not fall within the definition of tangible personal property. That definition treats a license of pre-written computer software as a sale of tangible personal property, but apart from that situation, online services are not caught. If you are caught by that two-pronged threshold, you'd better get moving. The guidance doesn't give a specific start date, but it does say this: if you are a business that meets this threshold but has not yet registered as a vendor, you should do so now. The inference being that you will be expected to register immediately and file your return for the quarter December 1 through February 28. Your status in regard to the 2 earlier quarters, which have expired since the Wayfair decision, is unclear. For a copy of Notice N19-1, please go to our website. And now for this week's treaty developments. We've had 1 protocol signed and 3 treaties enter into force. I have 3 articles for you this week. The first is called A Deconstruction of the Principal Purpose Test. It's written by Stef van Weigel and it's published in the January edition of the IBFD's World Tax Journal. In fact, there are 2 articles on the PPT in that edition of the World Tax Journal. I'll tell you about the other one in a few moments. Here's a quick reminder of the text of the PPT, as contained in Article 29.9 of the 2017 OECD Model Treaty. There's a slightly different version in Article 7.1 of the MLI. As you can see, it has 2 limbs, which I've called the positive limb and the negative limb. Although some commentators have argued that the 2 limbs should be interpreted holistically, the balance of opinion seems to be that the second limb, the negative limb in my terminology, should be interpreted as an exception or a proviso to the first limb, the positive limb, as shown by the use of the word unless at the start of the negative limb. By the way, the authors of these 2 articles on the PPT use different terminology to refer to the 2 limbs. Stef van Weigel calls the first limb the subjective test, despite the fact that a number of commentators consider that the first limb requires an objective test to be applied, and he calls the second limb the objective test. The author of the second PPT article, Craig Elif, calls the first limb the substantive test, and he calls the second limb the proviso. Stef van Weigel's article focuses on the second limb, the negative limb in my terminology. Amongst other things, he reviews the OECD commentary and the examples therein, and he finds it difficult to nail down exactly what the negative limb requires, which, in my view, is a design feature of the PPT. In other words, the PPT was drafted to be unclear. Stef van Weigel alludes to this issue in his conclusion. The reach and potency of the PPT have the potential to create significant uncertainty in the application of tax treaties, not the least because the commentary on Article 29.9 of the 2017 OECD Model Treaty and the examples provided therein failed to articulate a clear principle. While to an extent that uncertainty may serve a policy goal, that is, deterring the improper use of tax treaties, it may also hamper achieving the overarching object and purpose of tax treaties, that is, removing obstacles to international trade and investment. The second article is called The Meaning of the Principal Purpose Test, One Ring to Bind Them All. It's written by Craig Elif and it's also published in the January edition of the IBFD's World Tax Journal. The author is one of the commentators who consider that the first limb of the PPT, the positive limb in my terminology, requires an objective test to be applied. He writes, "The question posed is to what extent one should consider the taxpayer's intention or motive in undertaking the transaction when applying the PPT. The answer is, at least in theory, not at all. The focus on the taxpayer's intention is not helpful because the wording of the test does not refer to the taxpayer's state of mind, but requires an objective assessment of the principal purposes of the arrangement or transaction. While a taxpayer's subjective intention or motive might indicate one or more purposes for the transaction, that is not the focus of the test." This article considers both limbs of the PPT, and I would say that it is easier to read than Steph Van Wegel's article. The third article is called "The German Proposal for an Effective Minimum Tax on MNE Profits." It's written by Johannes Becker and Joachim English, and it's published in the Kluwer International Tax blog. This article describes the third of the three proposals which are currently being considered by the OECD's Task Force on the Digital Economy and the Inclusive Framework. Firstly, taxation of digital services in situations where there is significant value created by user participation. Secondly, a broad-based increase in the tax rates of market jurisdictions. And thirdly, a global minimum tax. The authors describe how the German proposal for a global minimum tax, not surprisingly, is based on self-interest. The public opinion in Germany, as elsewhere, pushes for action against tax-saving arrangements and aggressive tax planning by big tech companies and other multinationals. But Berlin is, at best, lukewarm in its support for the digital services tax. The expected revenue seems too low to justify the resulting cost in terms of complexity. And since the tax is effectively targeting primarily American internet companies, there is the plausible risk of international retaliation, for example, in the form of American punitive tariffs. A general shift of taxation to the market jurisdiction, on the other hand, is not in the German interest, given its huge and persistent export surplus, as such a reform would probably be costly for jurisdictions that produce more than they consume and invest. The article explains the two prongs of the proposed global minimum tax. If the jurisdiction that is entitled to tax business profits under the established rules of international taxation makes sufficient use of its right to tax, nothing changes. If, however, the tax burden on corporate profits is too low there, a supplementary minimum tax will be levied. This subsidiary right to tax would rest either with the country of residence, that is, in the country where the firm has its headquarters, or where the ultimate parent or an intermediate holding is situated, or with the market jurisdictions, the country where the goods and services are sold and paid for. The issue which is embedded in this passage is the priority rule, residence jurisdiction first or market jurisdiction first. The article briefly refers to that point, but does not address it in depth. Well, that's the way it is this Friday, the 25th of January 2019. I'm Steve Towers. Have a great weekend.